Good afternoon to members of the media and to all those who are listening to this video broadcast. I have decided to respond to media statements in which Petrotrin is being urged to challenge the decision of the arbitrators by starting another judicial process in the High Court, which process can lead to the Court of Appeal and then to the Judicial Committee of the Privy Council. Since this process would involve the expenditure of taxpayers' monies, it is very important for me to alert the public of the circumstances of this matter, again, so that the public can judge for themselves. The Board of Heritage is being pressured to have Petrotrin appeal the arbitrator's judgment through an opinion written by senior counsel, Mrs. Deborah Peake, which was supposedly mysteriously sent to the media and published today. In it, Petrotrin is being encouraged to spend more public monies to start a judicial process to challenge the arbitrator's decision, which judicial process would go before the High Court and which can then end up before the Court of Appeal with a further appeal to the Judicial Committee of the Privy Council. As with the internal audit report, this opinion has apparently been handed to the media, but no one knows how. It apparently was not Petrotrin, it was not Heritage, and no one presumed Mrs. Peake. It is just one of those misfortunes that only happen with this state enterprise. It is reported in the opinion of Mrs. Peake that she advised that there are good prospects of success in going to the courts. It is my view that the only good prospects of success are that the lawyers will be making more money and ultimately the people of the country would have to pay. It must be remembered that it was based on the opinion of Mrs. Deborah Peake that Petrotrin did not resolve the dispute with A&V before the arbitration process started. Also, after the arbitration process started, it was because Mrs. Peake's opinion was that Petrotrin had good prospects of success that A&V was vindicated in the arbitration. I think it is important for me to bring to the attention of the public what Mrs. Deborah Peake stated at the conclusion of the arbitration, because what she said then are inconsistent with the statement which is reported in the media that the arbitrators were guilty of misconduct in the conduct of the arbitration proceedings. I say these statements are inconsistent because at the end of the arbitration hearing on the 18th of December 2020, the official transcript of the arbitration would see that she told the arbitrators, and I quote, "On behalf of the respondent," that is on behalf of Petrotrin, "I think I can speak to my learned friends," this is Mrs. Peake speaking, "for the claimant. I wanted to thank you, Sir Dennis, Lord Hope, Justice Tolmeyer, for presiding over these proceedings so smoothly over the past 3 weeks, and even before in the pre-hearing days. You were able to deal with anything that the parties threw at you calmly and efficiently, and your rulings were always prompt and, more importantly, fair." I stress that, fair. In other words, Mrs. Peake was saying that a fair hearing was conducted by the arbitrators. Mrs. Peake went on to say, "I think the parties, if I may say so, should be commended for their selection of the tribunal. We could not have asked for a more eminent, experienced, and mature panel. So here it is, Mrs. Peak was saying that this was an eminent, experienced, and mature panel. This was truly, she said, this was truly an international arbitration. We had representation from Trinidad, St. Lucia, Scotland, the United States, and Canada. It is for us a model of how one can conduct complex litigation remotely in the 21st century. Those statements are totally inconsistent with what is reported in the newspapers today, that Mrs. Peak is saying that the arbitrators were guilty of misconduct in the conduct of the proceedings. These are just words. There are no errors in this judgment, in my respectful view, of no errors that the judges have made on the face of the record. There is also no basis for an application to be made to the High Court other than to tactically delay the inevitable result in this matter and to incur costs. The only people who will benefit with this kind of action are the lawyers. Mrs. Peak, on behalf of Petrotrin, agreed for these three arbitrators to determine the dispute between A&V and Petrotrin. Mrs. Deborah Peak, on behalf of Petrotrin, chose the arbitrator, Justice Humphrey Stallmeyer, a former Justice of Appeal of the Court of Appeal. A&V chose the arbitrator, Lord David Hope, a former judge of the Judicial Committee of the Privy Council. And Mrs. Deborah Peak, on behalf of Petrotrin and A&V, agreed for Sir Dennis Byron to be the arbitrator and chairman of the panel of arbitrators. The three arbitrators were therefore agreed to by Mrs. Peak on behalf of Petrotrin and by A&V. They agreed for these three arbitrators to determine the dispute between A&V and Petrotrin. By the terms of the contract, Petrotrin agreed that it would not review or challenge the decision of the arbitrator. So here it is, we have three distinguished arbitrators who have agreed to conduct this dispute in which the government-owned company Petrotrin was involved. And notwithstanding all that they have said about the arbitrators, when Petrotrin does not get a judgment that its senior counsel does not like, it wants to challenge it. Mrs. Peak, on behalf of Petrotrin, had every opportunity to present to the arbitrators all the evidence Petrotrin wanted to present. And Mrs. Peak, on behalf of Petrotrin, had all the opportunity to cross-examine the witnesses who were called on behalf of A&V. The oral hearing before the arbitrators lasted for 14 days, during which time the witnesses on behalf of both A&V and Petrotrin gave evidence and they were cross-examined. It would be contrary to the public interest for the government to allow Petrotrin, in the circumstances, to waste public funds where Petrotrin had every opportunity to prove its case before these three distinguished judges. It would be contrary to the public interest for government to permit Petrotrin to pursue at the expense of the taxpayers these frivolous challenges to the decisions made by these three distinguished arbitrators. If the government permits Petrotrin to challenge the decision of the arbitrators in the High Court, the matter is likely to go to the Court of Appeal and then to the Judicial Committee of the Privy Council. Can you imagine how much the legal costs and expenses would be imposed on the taxpayers of Trinidad and Tobago, certainly in the region of millions of dollars? The new board of directors of Petrotrin should not make the same errors which the previous board of directors of Petrotrin made. The damages in this matter would not be in the region of $1 billion, as alleged in the newspapers. That is an exaggeration. The damages would be assessed in the same way as the court assesses damages suffered by any company when there is a wrongful termination of the contract. The best interest of the taxpayers now is for Petrotrin at this stage to cut its losses and to enter into negotiations with A&V for this dispute to be resolved. The losses which Petrotrin has incurred due to the findings of the arbitrators is because Petrotrin was advised that it had good prospects of success. It has been shown by the decision of the arbitrators that Petrotrin did not have any good prospects of success. The new board of directors of Petrotrin should not make the same mistake that the last board of directors made in acting on an erroneous basis that there are good prospects of success. The fact that a person may have a right under the Arbitration Act to challenge the determination of an arbitrator does not justify a government to permit a government-owned company to pursue frivolous challenges against a decision of the arbitrators. This is especially so when the government-owned company agreed to the appointment of the arbitrators and the government-owned company had ample opportunity to prove its case before the arbitrators. And this is especially so when at the conclusion of the arbitration hearing, the senior counsel for the government-owned company praised the arbitrators, praised their fairness, praised their eminence, praised their experience, and praised the mature panel. And when the government-owned company loses the arbitration, the government-owned company is very critical and making unwarranted attacks on the arbitrators. My call, therefore, is renewed for the government to lay the judgment of the arbitrators in the parliament so that it becomes a public document, so that members of the public and the media can see and assess for themselves what happened in this matter, in which, because the leader of the opposition made statements against the Prime Minister, and those allegations having been made on a public platform, the then chairman of Petrotrin was pressured into conducting an investigation into the allegations made by the leader of the opposition. And based on the fact that Petrotrin was advised that there was good prospects of success, A&V has been vindicated. So here it is, the new board of directors have to make a decision. Is it going to allow the leader of the opposition to go back at a public meeting and make the same allegations by saying that although the arbitrators decided in a particular matter, the arbitrator decided that the allegations with Petrotrin made, A&V has been vindicated. Is this new board of directors of Petrotrin going to allow taxpayers' monies to be spent on these frivolous allegations? That would be a misuse and abuse of power, and the government should not permit that to happen. As I said before, I have a duty in the public interest to draw these matters to the public, draw these matters to the board of directors, and to draw these matters to the country as a whole. I have sent a copy of this statement to the chairman of Petrotrin. I have also sent a copy of the statement I made yesterday to the chairman of Petrotrin. I am doing that because whatever happens in this case, I want to be able to come back to the public, whichever this way the decision goes for the government or the board, to come back to the public to say what again would be the result. Because I told this country, I told the members of the public in several press conferences I had that Petrotrin made an error. They had no case against A&V, that Petrotrin would not succeed, and the taxpayer would be saddled with a lot of money to pay. And I'm saying again, today, that the new board of directors of Petrotrin should think carefully in making any decision to support this alleged good prospects of success against the decision of these three arbitrators. These three arbitrators were not judges of the High Court at the time or judges of the Court of Appeal. They are judges, Lord Hope, but let me first start with Sir Dennis Byron. He was last the president of the Caribbean Court of Justice. That is the appeal court for Caribbean countries from their Court of Appeal. Lord Hope was a judge of the Judicial Committee of the Privy Council, which is the final Court of Appeal for Trinidad and Tobago. And Justice of Appeal Stolmeyer was a judge of the Court of Appeal of Trinidad and Tobago. Thank you. Very good afternoon.